This Swanson Reed presentation provides information regarding R&D tax incentive taxpayer alerts published by the ATO in December 2023. Taxpayer alerts are specific publications which provide a summary of ATO concerns about new or emerging high-risk tax arrangements which will likely be a focus of future ATO compliance activity. Taxpayer alerts are intended to be high-impact publications which the ATO use to bring high attention to affected taxpayers and arrangements. Each taxpayer alert describes an arrangement, ATO concerns, and what the ATO are currently doing about the arrangement. Taxpayer alerts do not provide the ATO's view, but will often state if the ATO expects to issue advice or guidance about the arrangement following the taxpayer alert. Taxpayers that have affairs covered by ATO alerts should consider whether they may need to take action to adjust their affairs, including making a potential disclosure to the ATO. The ATO had previously issued multiple alerts for issues impacting the R&D tax incentive in February 2017 regarding concerns around R&D claims for software development, ordinary business activities, and other issues. These 2017 alerts marked the commencement of a period of heightened compliance activity by the regulators for R&D tax incentive claims. The ATO issued 2 new R&D tax-specific taxpayer alerts on 14 December 2023. One publication concerned R&D activities conducted overseas for foreign-related entities, which will be the focus of this presentation, and another publication relating to R&D activities delivered by associate entities. It is expected that the 2023 taxpayer alerts may also mark the commencement of increased compliance activities by the ATO. The relevant December 2023 alert covered in this presentation was titled TA 2023/5 Research and Development Activities Conducted Overseas for Foreign-Related Entities. The ATO have noted that they are currently reviewing arrangements where Australian resident R&D entities claim a tax offset under the R&D tax incentive for expenditure incurred on R&D activities conducted overseas. The ATO are concerned R&D entities might be incorrectly claiming the R&D tax offset, irrespective of whether the R&D entity may have an overseas finding covering the R&D activities being conducted overseas, or whether under the contractual arrangements between the R&D entity and the foreign-related entity, the R&D entity purportedly has an interest in any developed IP, know-how, or other results arising from the R&D entity's expenditure on the R&D activities. An illustrative example is provided in the alert and displayed here. The example outlines a potential iteration of an arrangement with features that may concern the ATO. The alert notes that common features of relevant arrangements include a foreign-related entity, such as a well-capitalised biotech, may cause an Australian R&D entity to be incorporated. Under an agreement between the foreign-related entity and the Australian R&D entity, the foreign-related entity grants to the Australian R&D entity a license to use and develop the foreign-related entity's existing intellectual property. The foreign-related entity receives primary rights to exploit any developed IP or other results from the Australian R&D entity's overseas activities upon that IP's creation. Also, the foreign-related entity provides funds to the Australian R&D entity to conduct its R&D activities. Another feature of concern is that the Australian R&D entity has limited assets, minimal staff, and negligible industry research experience, requiring it to contract out the conduct of its R&D activities, whether those activities be conducted within Australia or overseas. Also, R&D activities that are conducted overseas purportedly for the benefit of the Australian R&D entity are contracted out to a CRO. The Australian R&D entity has limited ability to itself commercially exploit the developed IP. Under arrangements of concern, the Australian R&D entity obtains an overseas finding and lodges the application with AusIndustry. The Australian R&D entity claims a notional deduction for expenditure it incurs from the CRO and thereafter an R&D tax offset. However, upon objective review of the financing, licensing, service, corporate or other arrangements between the Australian R&D entity and the foreign-related entity, it appears that the foreign-related entity is the sole or major beneficiary of the Australian entity's overseas activities. Arrangements of concern are those where the R&D activities are, to a significant extent, conducted for the benefit of the related foreign entity and may display some or all of the following features. The arrangements between the foreign-related entity and the R&D entity are established by and under the instruction of the foreign-related entity and its controllers, directly or indirectly result in the foreign-related entity ultimately acquiring ownership rights in the developed IP, which arise from the R&D activity. For the period of the R&D entity's ownership of the developed IP, impose restrictions on some or all of the R&D entity's rights around the developed IP. For the period of the R&D entity's ownership of the developed IP, grant to the foreign-related entity primary rights to exploit and itself manage the developed IP. Also, arrangements may have a legal form that is inconsistent with the actual commercial substance of the arrangements between the entities. In addition, the foreign-related entity owns the pre-existing IP, which is licensed to the R&D entity to undertake the R&D activity. And in substance and effect, the foreign-related entity assumes the financial risk in relation to any funds committed to the R&D entity for the purpose of financing the activities, sets the conditions for initial and subsequent funding of the R&D, assumes the operational risk for conducting the R&D activities, and controls the strategic decisions regarding the R&D activities, including the instructions given to any contracted CRO as to the way the R&D activities are to be conducted. Also, the foreign-related entity may itself be contracted by the Australian R&D entity to conduct some or all of the activities. Also, it's been observed by the ATO that the Australian R&D entity may not have a physical presence in Australia, may have one or more foreign resident directors that are consistent with that or are appointed by the foreign-related entity, has an Australian-based resident director that acts in accordance with the directions and wishes of the foreign-related entity and its controllers, has few, if any, employees with the technical ability to conduct the R&D activities. In the absence of either original and future committed funding from the foreign-related entity or receipt of a refundable R&D tax offset, lacks the economic capacity to either conduct the R&D activities or commercially exploit the developed IP. Also, the ATO have observed instances where the Australian R&D entity may have been incorporated shortly before the end of the relevant financial year in which the R&D tax offset is first claimed. In respect of the arrangements covered in this alert, the ATO are concerned that affected R&D entities do not qualify for expenditure incurred by them on R&D activities conducted overseas because the activities are not conducted for the Australian R&D entity, or the activities were conducted to a significant extent for the foreign-related entity, and that entity does not satisfy the statutory conditions for eligible R&D activities. Alternatively, where the R&D entity is an Australian resident and the R&D activities are conducted for that R&D entity's own benefit, the R&D entity might not qualify for an R&D tax offset as the expenditure incurred by them might not be at risk for the purpose of the risk integrity rule under the R&D tax incentive law, or Where the conditions for entitlement to an R&D tax offset are satisfied, if viewed objectively that one or more parties to the arrangement entered into or carried out the arrangement for the purpose of obtaining a R&D tax offset, the general anti-avoidance provisions in Part 4A may apply to cancel the R&D tax offset. Key takeaways to be mindful of following the ATO's publication of TA 2023/5 include: whilst the headline and content of this alert suggests that the ATO's main concern relates to where overseas R&D activities are being claimed, some of the concerns in this alert may also apply to arrangements of concern to restrict eligibility of R&D activities conducted in Australia, where it is deemed that the Australian R&D activities are conducted wholly or to a significant extent for a related foreign entity. R&D entities must carefully analyse the legal and commercial substance and form of their structural arrangements to determine which entity R&D activities are conducted for and whether the at-risk integrity rule may apply. Where companies are conducting R&D activities on behalf of an associated foreign corporation, they must comply with the specific and additional requirements under Section 355.220. The key conditions of this provision include that the R&D activity must be conducted solely within Australia, the relevant foreign entity must be located in a country that has a tax treaty with Australia, and the entities must comply with specific requirements for intra-group contracts, documentation, and service charges. That concludes our presentation on Taxpayer Alert TA 2023/5. Please see the ATO or Swanson Reed websites for additional information, or alternatively, please contact our office if you have any questions. Thank you for listening.